Yeah.
Okay, very good.
Okay. Can you introduce yourself, please, and tell us your background, please?
Sure. My name is John Eastman. I'm a professor of constitutional law and former dean at the Chapman University Fowler School of Law. I'm also serving this year as a visiting scholar at the University of Colorado at its Benson Center, and I'm a senior fellow at the Claremont Institute.
Thank you. Professor Eastman, I believe you're going to talk to us today about the electoral college process and how that affects the legislature here.
Sure. Thanks very much. And Chairman Ligon and the members of the subcommittee, thank you for inviting me to testify at this very important hearing. My scholarly work and expertise have always revolved around the structural provisions of the federal Constitution. And because of that, similarly, 20 years ago, I was invited to testify before the Florida legislature as they were dealing with issues similar to what you're dealing with now. At that time, no one had given much attention, scholarly or otherwise, to the role the Constitution assigns to state legislatures in determining the manner of choosing electors. And it's a little bit foreign to us now because we haven't really done what the Constitution authorizes fully for a very long time. The last time the issue really came up was in the election of 1876, and I don't think any of us, maybe Mayor Giuliani, I don't think any of us were around back at that time. But in the wake of that controversy, Congress passed the Electoral Count Act of 1887, and which aimed to clarify some of the processes. That act, too, didn't get much attention until the 2000 election down in Florida. And before we really got into the intricacies of that act, the Supreme Court's resolution of the case in Bush versus Gore kind of ended the matter. But since then, there's been a whole lot of scholarship done. And most of it is confirmed with the written testimony I gave to the Florida legislature there. And it's that process that I want to focus on. Let me begin with the relevant provision of the U.S. Constitution that Ray, you talked about earlier in your testimony this morning. Article 2, Section 1 provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors to which they're entitled. The Supreme Court has described this constitutional authority of the state legislatures as plenary. That means it knows no other limit, that the legislature gets to do what it wants. That was in a 1892 case called McPherson versus Blacker, and it was reiterated by the Supreme Court in the Bush versus Gore case back in 2000. It even is noted that whatever provisions may be made by statute or by the state constitution to choose electors by the people, there is no doubt that the federal Constitution gives the right to the legislature to resume that power at any time. That's again McPherson, and the Bush versus Gore decision reiterated that. In the early decades of our nation's history, most state legislatures selected their state's presidential electors themselves. Only after 1824 did a majority of state legislatures move toward choosing their electors by popular vote. But your neighboring state legislature up in South Carolina continued to choose its state electors by itself all the way up until 1860. Nevertheless, the constitutional power to decide on the method for choosing electors remains exclusively with the state legislatures. Now, to be sure, the authority to take back that power and appoint electors at any time, as the Supreme Court said in McPherson, would likely not allow a legislature to pick its own slate of electors after the results of a fair election, which have been conducted pursuant to the legislature's existing statutory procedures, merely on the ground that the legislature didn't like the outcome that the popular vote had chosen. As the Supreme Court said in Bush versus Gore, when the state legislature vests the right to vote for president in its people, the right to vote as the legislature has prescribed is fundamental. But that's not the case when the existing procedures are not followed, and when significant statistical anomalies and other evidence raising serious questions about voter fraud and about whether the election was fair. In such cases, the manner for choosing electors set out by the legislature was not followed. The constitutional default of the legislature exercising its plenary power, or rather resuming that power, is therefore again brought to the forefront. As the court noted in Bush versus Gore, the right to vote in election for presidential electors is fundamental when done in the manner the legislature has prescribed. Now, what you've been hearing today is a lot of testimony about how the statutes that you had prescribed for the manner of choosing electors were not complied with. By the way, this is all in perfect line with federal statutory authority as well. Section 2 of Title 8 provides that whenever a state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such manner as the legislature of such state may direct. The failure of state election officials to follow the manner you had set out in statutes in conducting this election, as well as the intermingling of illegal and legal ballots in significant enough numbers that the election can't be validly certified, quite simply means that the state has failed to make a choice on election day in accordance with the manner that you've prescribed. And the appointment of electors, therefore, both under Article 2 and Section 2 of Subtitle 3, devolves back on the legislature of the state, which has plenary power to decide whether and how to exercise the appointment power itself or craft some other mechanism to cure the problems with the state election that occurred. That is what the Florida legislature was prepared to do in 2000, prior to the resolution of that state's election controversy back in 2000. The vote on that day had been certified by the Florida Secretary of State, but the state Supreme Court had, contrary to state law, ordered a recount in only heavily Democrat counties with the expectation that that would flip the vote that had been certified. The relevant committees in the Florida legislature, both houses, crafted identical resolutions that would allow the legislature to reclaim its plenary power of choosing its own slate of electors. Those resolutions passed out of the relevant committees, and they were already scheduled for floor votes where they were expected both to pass when the Supreme Court issued its decision in Bush versus Gore, making that unnecessary. Violations of Georgia election law here, which is to say the manner that the Georgia legislature has established for choosing the president electors, are numerous. As you've been hearing testimony all day today, the number of underage individuals who are allowed to register contrary to the statutory authority amounts allegedly up to approximately 66,000 people. 2,500 people who are convicted and incarcerated felons were allowed to vote and have those votes counted contrary to state law. Proofs of identity that are required under state law were not complied with. Voters, as you just heard, moving from one county to another before a 30-day window, as the statutes allow, were allowed to have their votes counted and cast in the prior county of their residence, contrary to state law. A number of voters don't even have registration of residential addresses, but P.O. boxes, and have been allowed to vote and cast ballots, contrary to state law. I think the biggest one is a result of the March 2020 settlement agreement that was entered into with your Secretary of State and certain Democrat committee challengers that effectively altered the signature verification process for your absentee ballots in ways that are contrary to state law. Those state statutes are all designed to help prevent fraud, and yet their violations now then have created a serious problem with the potential for fraud. Just on the absentee ballots itself, the signature verification process normally results in the rejection of about 3 to 4% of absentee ballots for failing to include a residential address or for signatures that clearly do not match those on registration. Because of the changed procedures as a result of that settlement agreement, and that was agreement that was entered into without any involvement of the legislature, which means it was done contrary to the U.S. Constitution's authority in Article 1, Section 2. The rejection rates in this election were like 1/3 of 1%, with the resulting about 40,000 ballots that would have been discounted or rejected historically were allowed to be cast and counted. That's a significant deviation from the manner that this legislature has set out. These significant statutory violations are, in my view, more than enough in the way of the alteration of the legislature's approved manner of choosing electors to warrant this legislature from taking back its plenary power to determine the manner of choosing electors. You could do that by calling a special election, although the time is very tight for that and may be logistically impossible. But you could also do what the Florida legislature was prepared to do, which is to adopt a slate of electors yourself. And when you add in the mix of the significant statistical anomalies and sworn affidavits and video evidence of outright election fraud, I don't think it's just your authority to do that, but quite frankly, I think you have a duty to do that, to protect the integrity of the election here in Georgia.